I'm Vinny Politan. Great to have you with us tonight here on Closing Arguments. And I'm going to throw a term out at you that you've probably heard many, many times if you've been watching court TV and watching trial coverage through all these years. The battle of the experts. The battle of the experts. Hear it many times. It's happening in the case in Minneapolis, the case against Kim Potter. It also happened in the Derek Chauvin trial. And something unbelievable happened in that case. There was an expert who almost achieved sainthood. He was the most credible expert in the history of any trial. At least a lot of people said that, okay? And obviously I'm exaggerating just a little bit here, but in that battle, he won that battle, and we know he did because of what jurors said afterwards. Of course, I'm talking about, or maybe you don't know who I'm talking about, Dr. Martin Tobin, who was the pulmonologist, the expert who really turned into more than an expert. He won the case for prosecutors. He absolutely did. And one of the reasons was because of one part of his testimony. Do you remember this?
Would you tell the ladies and gentlemen if you're getting paid for your time in this case?
No, I am not getting paid.
And why is that?
Well, when I was asked to do the case, I thought I might have some knowledge that would be helpful to explain how Mr. Floyd died. And since I'd never done this type of work in this nature before, I decided I didn't wish to be paid for it.
They never say that. Experts never say it. No, I have some knowledge. I know what this is about. No, I don't need to get paid. I don't need to get paid. And that just took his testimony and his credibility from here to here, because that's what the battle of the experts is all about. It's about credibility. And I remember during that trial talking about that moment and how that elevated his credibility, because the defense was not going to have an expert come in and say, you don't have to pay me for this. Of course, they get paid. It's normal to get paid. It is a normal part of the process. The thing that is not normal is when the expert testifies and is not paid. So let's go back to the trial that we're covering now in the same courtroom, in the same courthouse, same prosecution team. But now we're in the defense case. And the defense use of force, which is what this case is about, in part, use of force expert testified. Take a listen to what he said.
Are we paying you to be here?
No, sir.
And why is that?
I've decided in the mid-90s when this process began, I began asked to review cases that I would never take a fee in a criminal case regardless of the side that was calling me. I'm not Mr. Benevolent. I like to get paid like anyone else. But I just felt that something as significant as someone's freedom suggested I should give an opinion without any question about motivation. I may say things you don't agree with, but I don't think the issue of money coming into it should be a consideration. So I just decided in the 90s I would never take a fee for a criminal review of any kind, regardless of the initiation, but I've stood by that, and if I continue to do this, I'll continue to take that perspective.
Unbelievable, right? And I've been telling you, this is not the Derek Chauvin trial, and it's much different, and things are turned this way. And with the experts on that issue, absolutely, big difference. Battle the experts. Who wins the credibility there? The one who says, no, I just come in and give my opinion. Well, in Derek Chauvin's trial, Dr. Tobin won that battle. Now the question is, will Stephen Imes, the expert for the defense, win the battle in this case? Let's bring in Court TV legal correspondent Chanley Painters joining us live from Minneapolis, Minnesota tonight. Unbelievable. I know we were kind of exchanging text messages and everything today about this whole thing. Chanley, so he doesn't take a fee. What did he have to say to this jury?
He had a dynamic, direct examination, and he comes from a position of experience, 43 years in the law enforcement business, and that was noted by these jurors in those reporter notes, Vinny. His background as a police chief, as a trainer, as a use of force expert, working for free, and he had opinions based on his view of the body cam video, the dash cam video in this incident. He talked first about his opinion on whether or not the use of a taser, which we know Kim Potter intended to use that day, was appropriate. Let's listen.
Was Officer Potter's perceived use of a taser consistent with contemporary and professional police training and practice?
Yes, sir.
And why?
The basic model policy definition of when the device would be used is completely relevant here. Grounds to arrest or detain, and a reasonable belief that physical force and resistance would follow. That was happening right before your eyes. And secondarily, when the physical control effort began and the dynamic nature of how he's trying to get away clearly needs to be stopped. Just getting in the vehicle is significant, but officers would be aware of that weapons component and the concern, could there be a gun in the car? Could there be a gun on him? This isn't just about might this person drive away. So the need to stop it as quickly as possible is the key aspect. Nothing but the taser in that scenario had a likelihood of doing that without a risk of serious injury or death. The continued grapple, if you don't get that done and that car gets in drive, it's going to get bad. And the taser is that unique device that when performing as designed and intended would have put a stop to it, very, very likely in most cases.
The officer sees Johnson in the car,
Yes, sir.
sees him struggling in the car and has a view of him. And further, that the individual is about to drive away, or at least attempt to drive away, with an officer who's in and out of the car. Would that officer who sees him be reasonable in the use of deadly force in the face of Mr. Johnson's apparent risk of great bodily harm or death?
I'll object, Your Honor, as calling for speculation and improper standard.
The objection is overruled. You may answer.
The question, sir, would be answered first by just understanding the basic decision-making process involving deadly force, and that is, can I reasonably articulate a belief that myself or another is in immediate danger of risk of death or great bodily harm? So if that's the standard, as an officer assessing the appropriateness of deadly force, an officer half in and half out of a vehicle that is about to be put into drive with the door open would certainly meet that standard of being in immediate danger of death or serious physical injury.
Okay. So an officer seeing that could shoot?
It would meet that standard and an officer could shoot, yes, sir.
So this use of force expert Vinny saying that a taser would have been appropriate under the circumstances, and if Potter was aware that Sergeant Johnson was half in and out of Wright's car at the time, deadly force would have also been appropriate. He also spoke to that warrant, that it's a dereliction of duty for an officer not to execute an arrest when someone has a warrant out for their arrest.
How about on cross-examination? What happened there?
Right. Well, Matthew Frank tried to change the narrative a little bit. He pointed out that this was an expert who talked about deadly force, but with that caution of whether Potter knew that Johnson was in or out of the vehicle. That seems to be a main point of contention. Whether Sergeant Johnson was halfway in or halfway out, this expert was said, well, he was more out than in, so he made that point on cross-examination. Also, there was a moment where Frank said, wouldn't it be a dereliction of duty, using his words on direct, for an officer to use unreasonable force? And he agreed with that. No major mountains were moved on cross-examination, Vinny, but a couple little things to try to get him, this jury, to look back to what this prosecution wants them to believe.
Okay, how about Kim Potter's former boss, the old police chief from Brooklyn Center, testifying today?
Right. He was also a powerful witness for this defense. He was, again, the police chief at the time that this happened, and he told this jury not only that, Kim Potter was a good person and a good police officer, but that he also reviewed the body cam video, and under his, expertise of the policy and the procedure of the Brooklyn Center Police Department, that he reviewed all three officers, what they did in that traffic stop. It was all appropriate. He also told this jury, under the circumstances, it would be reasonable and necessary to use a taser in the incident, and under that circumstance, if Johnson indeed was half in that car, to use a gun in that circumstance. But on cross-examination, again, the prosecutor tried to undercut some of that by trying to expose some motive or bias. Let's listen.
Officer Potter, or Kim Potter, was involved in the shooting incident, and the aftermath of that related to the political pressures within the city. I was no longer allowed to stay as the chief of police.
And was that because you would not terminate her until she had a due process hearing? Objection, meeting.
The objection is overruled on that ground. You may answer.
I believe one of the reasons that I was required or requested to leave the agency was because I would not immediately fire Kim Potter.
Did Kim Potter leave voluntarily after that? Quit her job?
She did resign her position to me while I was still the chief.
Vinny, that was on direct examination, but it was again brought up on cross by the prosecutor, trying to point out that he might have some affinity towards Kim Potter. In fact, that he lost his job because he wouldn't fire her over this incident. He also spoke to the media since that time, talking about the political pressures, and that was a consistent theme on cross, not only for this witness, but for a lot of the other character type witnesses later this afternoon.
Chanley Painter in Minneapolis. We'll talk again a little bit later on in the program. Thank you so much. Let's get some reaction from our think tank tonight. Joining us in the Bronx, New York, criminal defense attorney Renee Hill. In Houston, Texas, criminal defense attorney Carmen Rowe. And in Atlanta, Georgia, criminal defense attorney, law professor at Emory University, and Georgia Innocence Project board member Molly Parmer. Welcome to all. Battle the experts. Was this a knockout? Was this a TKO? Was this a draw? What happened here today, Renee?
I don't want to say it was a TKO, but I think it was a very, very good day for the defense. This witness was excellent for them. He presents very well, the use of force witness and her boss also. They both presented very well. And the prosecution's cross-examination of these witnesses has not been good. It's just really not up to par. It's very, very different from the way the prosecution was in the Chauvin case. So I think that the defense witness here that they have on, their expert witness, has produced a lot of information for this jury to give them a reason to find reasonable doubt.
Carmen Rowe, every opinion in this case so far has been that the taser was proper, the use of a gun was proper, except for one person, the paid expert from the prosecution. What does that mean to the jury?
Vinny, I'm having trouble with this. I'm trying to be objective. I agree the defense is killing it. I think that the prosecution is not doing the kind of work that you would expect them to do. But I have this fundamental problem, even listening to all these experts come in with this notion that the taser was okay or that shooting under these circumstances was okay. Every time I listen to these experts, it sounds like any time an officer is presented with a potential danger like the one that we saw here, albeit speculative at best in a lot of this testimony, it's okay to tase and it's okay to shoot. So I don't know if the people at home and this jury is looking at it the same way I am, but I have trouble with that. And again, I'm trying to look at it objectively and to be reasonable about what they're saying and to believe what they're saying. But I'm having trouble with it. But I do think that the defense is doing a great job. And I think for right now, it's their case on these issues, unless there are people like me who just have trouble with this fundamental idea that officers can shoot and kill people under circumstances that, again,
I'll lay this out to you,
speculative.
because I asked this of some other guests the other night. And I'll get to you, Molly. Wait, Molly's still waiting. She's ready. But Carmen, what do you want the officers to do? What do you want him to do right there?
Of course, I want them to be better trained. I mean, they talked about...
In that situation, Dante Wright is attempting to drive away in the car. They don't know if he has a weapon in the car. They know he has a warrant for a charge related to a weapon. They know that there is a restraining order against him against a woman. They don't know if it's the woman who's in the car. And the officer is 1/3 of the way in the car on the other side. So at that point, what do you want Kim Potter and Officer Lucky on the other side to do?
To be responsive but not proactive. I think they step back, they ensure their safety first, deal with these misdemeanor offenses they've observed second. Everything else is speculation.
You're going to let him drive away?
Absolutely. Misdemeanors for sure. I'm not killing anybody over a misdemeanor. I don't think police should be justified in that. That's all they knew he'd done.
What if as he's driving away, Officer Johnson gets dragged? You're okay with that?
From what I've heard, that's not certain. That's speculative. So if she acted based on that, perhaps we're in a different space.
Well, that's what we're hearing.
That's what we're hearing.
That's what we're hearing.
Well, we're hearing that may have happened, but that she wasn't even clear that she saw that in this case. That's what I'm saying. It's speculation at best where we are. Now, if she said, look, I saw my partner in danger. He could have been killed. That's why I reached for my taser or my gun. But that's not what we're hearing.
Right, Molly?
She's saying maybe that was the case.
Well, she thought she was going to tase him. And the prosecution said tasing's no good under this situation. Molly, there's a protective order, right? They know that there's some restraining order, protective order that Dante Wright is a subject to involving a woman. They don't know if it's the woman in the car or not. Are you okay? Someone has an outstanding arrest warrant related to a weapon, protective order against a woman. There's a woman in the car. Let him go.
I agree wholeheartedly with Carmen. And yes, I love this phrase that she used, be reactive, but not so, be responsive, but not reactive. And I think that in this case, we have to remember, for me, one of the most powerful pieces of testimony that I heard was Officer Lucky when he said the reason for the stop was an air freshener hanging from Dante Wright's mirror. That's what started all of this. Do I think that we should have cops patrolling the roads and pulling people over for a car freshener? I think that's excessive to begin with. And then you find out that he has warrants and he's trying to drive away. I think you let him drive away and you send the marshals out, you send the sheriff out, and you arrest him. And everybody, I think, in that situation would be in a much better place today. But I think Carmen is spot on. She's correct. And you never know with the jury. I think the fact that the defense
Why would the next arrest
said,
be any better? Why would the next arrest be any better if he's not going to go voluntarily on the side of the road with 3 officers around him? Why would he go when you show up at his house? Why would that be any better?
Because at that point now you have a tactical plan. Mm-hmm. It's a totally different situation. It's not as chaotic and dynamic like all of these people surrounding a car and just reacting at whatever's coming at them. It's a totally different situation when you have a team out that's effectuating an arrest. That's a totally different style.
Okay, let me ask you this, since we're in the world of what if the protective order was for that woman in that car? And what if he ends up hurting that woman in that car, and then all of a sudden we find out, well, they pulled him over and they knew there was a protective order and they let him drive away. How about that, Renee Hill?
So you're throwing a lot of what ifs out there, and there's no indication here that the young lady gave them any indication that she didn't want to be in the car with him, that she was feeling like she was in harm's way.
You've done work in domestic violence. You've done work in domestic violence. You know how the victims of domestic violence oftentimes are back with their abuser, sometimes voluntarily, sometimes not.
That happens a lot. And a lot of times they don't want the order of protection and the prosecution won't drop the order of protection. So you can't say just because there was a woman in the car and he has a domestic
I remember when
violence
police
history
pulled
that
over
there is an
another
issue
couple
there.
and let him go. When they pulled over that other couple, let him go, and Gabby Petito ended up dead.
And in that case, Gabby Petito was extremely upset. She was crying. Mm-hmm. Her demeanor was very, very different from what the demeanor of this young lady is. So you can distinguish between the two.
All right. Is there any responsibility for members of the public to comply with police? Is it a social contract between police who risk their lives to keep everyone safe and the public to comply when you say you're under arrest?
You should certainly comply, Vinny, but if you don't, you shouldn't end up dead. And I have a problem with this case, as you know, from us talking about it many times, that even when Officer Potter or Kim Potter was saying, I'll tase you, before she says taser, 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 she says, I'll tase you, I'll tase you. She had it in her hand already. And she should have seen it was her gun and not her taser. So I have a problem with that. And then they also
And that gets to the issue
off.
of the level of recklessness. That's exactly what the jury's got to figure out.
Yes.
You're
And
not
then this
saying it's
other
on
issue-
purpose. You're not saying it's on purpose, right?
It's negligence. It's criminal negligence, I believe. And then the other issue about him speeding off, and that they're saying that the other officers were in harm's way. And in my opinion, the moment in time from what I see of him speeding off is after he's shot. And that's a reaction to being shot. And then the car begins moving.
No, well, it's also a reaction to Officer Johnson getting out of the car as well, because he was holding it in park. He was the one preventing him from driving away. So a lot of moving parts. Great conversation. You all know what you're talking about. Police officers I've had on this show disagree 100% with all three of you, but we'll continue this conversation today.